Hello, my name is Nicholas from Baxter IP Patent Attorneys, and welcome to this week's patent news. So today we're talking to Greg Gering, who will be talking about how to commercialize your patent or product. Next we'll be talking to Chris Baxter, who will be using the onion ring analogy with reference to claim drafting. And finally we're talking to John Baxter about term sheets in patent licensing.
Hi, I'm Greg Gering. I'm from Baxter IP, and I am here today to talk to you about technology commercialization and the process of getting an idea and a patented idea through to market. So technology commercialization or technology transfer is the process of getting an idea from the workbench or the lab or the kitchen bench through to actually a product on the market. Now, that process can take a number of different steps. It can be very, very easy to just sell the idea to somebody, or to license the idea to a large organization who are in that market, or alternatively to build a business of your own around it. So I'll take you through those three steps. Building a business of your own around your idea is the best way to do this, because you don't have to convince anybody else of the validity of your idea. So what you need to do is you need to take the product that you've come up with, design it, get it manufactured, and take it to market. The difficulty with doing that, of course, is that you need a lot of cash and you need a lot of expertise. That's something that's very hard to come by. Normally, most inventors have one aspect of what it is they need and they're missing the others. So you need to find some money. Going to venture capital is very difficult because venture capitalists often want a very significant pound of flesh. If they're going to give you $1 million, they're going to want a lot of your business in the end. So you need to decide whether that's the path that you want to go down. The reason I say that that is the best way to do it is your destiny is in your hands. Instead of doing it yourself, you can always try the licensing route. If you find yourself a company that's interested in your idea and you want to start a negotiation about a license, that process is complex. Normally what it is that you need is you start with a confidentiality agreement, ensuring that they aren't going to talk about your idea if negotiations don't work. Secondly, you then start the process of negotiating what it is exactly they are going to do, and they are going to pay you for your idea. The difficulty is that for a company to take your idea on, they realize that they're going to need to spend a lot of money on research and development, getting your idea from concept, where it is at the moment, through to a final product that's on the shelves. They're going to need to spend money on sales, on marketing, on product development. That process is expensive, and at the end of the day, they're going to need to pay you a royalty. The reason that companies take these ideas on is that they don't need to spend the time and effort doing their own research and development into new products. So this is a viable path. What you will find, though, is that they are going to try and reduce the amount that they have to pay you as much as possible. So in the end, you have to decide what is it that you're trying to achieve. Do you want them to pay you an upfront fee and then they just can run with the idea, or do you want them to pay you royalties? The best model, as far as I'm concerned, is what's called exclusive licensing. You find one company, you license the idea to that one company, they have the rights to your product worldwide, assuming that the exclusive license is a worldwide exclusive license. The benefit of this is that the company will actually pay for all your patenting costs. Now, what you should really do is ask your patent attorney what your patenting costs are going to look like over the next 3 or 4 years, because they are very significant. If you, however, go for a non-exclusive license, i.e. you have a number of different companies licensing the idea from you, that means everyone is allowed to make the product, everyone's allowed to sell the product under a license from you, but no one will actually pay for your patenting costs, and that's something that you will need to pay for. So you need to make that decision: do I want to be paying my patent costs, which can add up to, $250,000, $500,000, or do you want to get somebody else to pay it and have an exclusive license with one company who can take your product to the world? The final option in terms of commercialization is to sell your idea. Find a company that's interested in what it is that you have, take it to them, have a negotiation with them, and just sell it to them for an upfront fee and walk away. Again, there's not much difference between this and an exclusive license in terms of the discussion that you'll have with the company up front. You need to just walk in the door, find out whether they're interested, and then start the negotiation. The difficulty you'll have really is walking in the door. A lot of companies get people walking in the door all day, every day, and trying to sell their ideas. You need to try and differentiate yourself from the pack. So you need to be able to walk in and very, very quickly explain what it is that you have and why it is that it fits in with that company's product range and with their business model. One aspect that I didn't mention was government grants. The Australian government has a number of grants available for inventors to take their products to market. For example, Commercialization Australia. The difficulty with getting those is you have to spend time writing up an application to them and going through their application process, but in the end you can actually get what I call free money. The government doesn't want the money back, they don't want a percentage of your business, they're prepared to just give it to you because they think that you have a good idea. It's a very, very useful way to get money, to take your idea further, to pay for experts, to pay for patenting. That's a very good way to progress your idea through to market. In conclusion, there are a number of different ways to take your product to market. You need to decide at the beginning what it is that you want from your idea. Do you want to just sell it? Do you want to build a business around it? Do you want to license it off? If you need any help, by all means contact Baxter IP. We have a number of commercialization people who can help. There are a number of websites that you can go to for assistance in this area. Look up technology commercialization, look up technology transfer, go to the IP Australia website, and of course go to the Baxter IP website. We have a lot of information on there. Thank you.
Well, I'm going to take a few minutes today to explain how patent claims work. If you've ever seen a patent specification, you'll notice it has a few distinct parts. It's got the description of the invention, it's got a background or a context to the invention, and it's got the claims. And the claims are legally what you're trying to encapsulate and what you're trying to stop other people copying. So the way patent claims are formulated is you have an independent claim. And an independent claim is your invention stated in the broadest possible way. So in this example, your invention might be a vehicle with 2 wheels and an engine control unit, a motorbike with an electronically controlled engine. Now, what can sometimes happen is that before your patent is examined, the examiner will do a search. And in that search, it's quite usual that the examiner will find some prior art. And some of it will relate to something completely different. For example, 4-wheel vehicles or hovercraft. But they might also find something that does cross over your broad definition of the invention. And here, the examiner has found a motorbike with an engine control unit. So what happens? Does your whole patent fall over? Well, this is the secret to good patent drafting. The secret is to create a finely tiered set of fallback positions. And they're what we call in a patent dependent claims. So you've got your broad notion of the invention, but if that, as is the case here, falls over and turns out not to be new or to be obvious, then you can drop back to your more limited definition of your idea. And here it might be where the engine control unit is configured to provide differential braking. So you can see that by limiting the definition of the invention incrementally, you're able to avoid the prior art. Every time you need to limit the definition of the invention, it's less likely that someone else is going to infringe on your claim. And of course, the whole purpose of a patent is to stop someone copying your broad idea. So when you draft a set of patent claims, you want to go as broad as possible, but to have a very, very finely tiered set of fallback positions so that whenever some prior art is found during examination, you don't have to limit the scope of the invention too much. And so that's the way patent claims work.
Hi, I'm John Baxter, one of Baxter IP's commercialisation advisors, and I'm very happy to share over the next few minutes our strategy in helping you commercialise your intellectual property via licensing. At Baxter IP, we have a number of strategies to help you commercialise your IP via licensing, and we work closely with clients to help you optimise your negotiating position and therefore maximise the commercial value of your IP. Proved to me the benefit of, initially at least, honing down to a basic term sheet with the other party, summarising the basic terms of the licence agreement. And only when the term sheet is iterated sufficiently to be agreed by both parties do we then revert to drafting a comprehensive licence agreement, which basically includes all the terms that have been previously agreed in the term sheet. At Baxter IP, we work with you to generate a term sheet which summarise the basic financial and other terms which will be included in the eventual licence agreement. This term sheet is your basic instrument which you are able to use when you negotiate your licence agreement with prospective licensees. This document is typically about 10 pages in length and is of a manageable size to be able to iterate during the licensing negotiations. When finally agreed, this term sheet is passed over to an expert intellectual property lawyer who then drafts a comprehensive licence agreement based on this term sheet. The comprehensive licence is typically 80 or 90 pages long.